Okay, we're about to start. Waiting for you to join this live stream. Today's Thursday, in October 17. We're gonna start once some of you join. I'm just waiting. I'm just testing all the devices to make sure that we're ready to go. Since we're not at 5 p.m. yet, I will be just talking a little bit, and then once you join, then we'll start. So yes, some of you joining this live stream. I'm Attorney J. Francis, and then we're gonna talk about U.S. immigration news and updates. Especially, we're gonna talk about marriage green card case. If you post the questions, then I'll be answering your questions. So, today we're gonna talk about marriage green card case and then other updates. Now, so I'm gonna start. So thank you so much for joining this live stream. So once again, for those of you who just joined this live for the first time, I'm Attorney J. Francis. I'm based in Chicago, but serving all 50 states. I do multi-platform live stream on Thursday, every Thursday, 5 p.m. Central Time. Binda. And then this is how I do, when you ask the question, I will answer any question. So then Binda asks, does 751 removal of conditions require interview or usually schedule for interview? I will tell you this. Our cases, the 751 removal of condition, it means that by the time that you got married, you're married in less than 2 years, and USCIS gave you conditional residency instead of 10-year permanent residency. Our case, whether they're submitted together or individually, USCIS rarely schedule interview. But answering your question, Binda, there is a little bit of additional factors. So for example, if you went through consular process, CR1 spouse visa to get a green card instead of inside the United States, then yes, there's a possibility that they schedule interview for you. So you got permanent residency, conditional residency through consular process. So there's a possibility. And number two, for your first case, marriage green card case, USCIS has some lingering questions, and they have some kind of note that invite this couple, back for interview for 751. So that's the second possibility. And the third one is that if you file 751 petition individually, it means that you're no longer together with your U.S. citizen spouse, then there is a good chance that interview will be scheduled. So three, sort of conditions. But for our 751 petition filed together with a U.S. citizen, never scheduled for interview. Okay. I'm just waiting. Okay, so SB came back. Thank you so much. That's a good question. SB asks, is there any reason why USCIS will interview you separately instead of together, right? So we talked about this many times. USCIS does not schedule interview for all cases, and if they schedule, there's more possibility that you will be interviewed separately. But why? Why, right? And then I will tell you this, right? There's many reasons why. And then, in most cases, USCIS like to test you extra by separating you. So they're not really completely convinced that you have a rock solid case. So there's some doubts. And then what's the best way to smell? And they find out that there are some issues and then not on the same page, couple, then you do separate interview. So that's done one way. The second reason is that it's not about foreign spouse per se, but sometimes it's a U.S. citizen petitioner. For example, U.S. citizen petitioner previously petitioned for somebody else and divorced, and then filed petition for that person previous, and all these complicated issues, and then they like to talk to that person. Or if one of you have some complicated issues, then they like to talk to you privately, when it's not relevant for both of you. So it can be sort of benign reason why they schedule separate interview, but in most cases, they like to check whether your, relationship is real. And then I'm gonna make another video on typical separate interview questions I did previously, but updated one. They will be asking same question to, both of you, right? U.S. citizen petitioner, foreign spouse, and then they're gonna see whether your answers match up. By the way, for those of you joining my live for the first time, I do multi-platform YouTube and TikTok, Facebook live Thursday 5 p.m. Central Time, and then usually Tuesday I only do TikTok. But next week I will do TikTok Monday and then multi-platform Thursday. I do Q&A, right? So far I only got a couple of questions, so I'm gonna talk until I have questions. But I look at all the screen to see a list of the questions are popping up. Thank you so much for joining today's live stream. But usually what I do is that Thursday, because it's a multi-platform, I have some YouTube, viewers who ask some questions. Then I usually do, start with updating, keeping families together, parole in place. Okay. Now, Binda asks again, can you provide USCIS a different mailing address? I'm just guessing that, your question is whether it's okay to provide, mailing address is different than your physical address. Probably that's what you're asking, right? You may, but in general, I prefer to provide the same mailing address and current physical address. I don't want to give the impression that somehow your mailing address is where you live. For example, most common scenario would be, your parents never move and then they never miss mail. Thus, I like to use parents' address. And when USCIS see this, your mailing address is different than your current physical address. They wonder why, what's the connection? Do you live there instead of this address? So, not recommended. Okay, the SB asked the question, is it okay to indicate to USCIS that your spouse has a disability? Types of disability, I'm not sure which one you're referring. The physical disability, you may, right? Officer will see, but if it's something different, then maybe I'm not sure whether you're speculating or telling us that your spouse doesn't have a good memory. I'm not sure. I can be totally wrong. Sorry, but I'm just speculating. But at the end of the day, if there's a good reasons why, one of your spouse have some sort of a limitation in fully remembering previous address, previous employment, and then be precise on information, then yeah, bring supporting documents. And not just hey, my spouse has a disability, but when you say that, then you need to back it up with a supporting documents. So one of you, user number, right, long number, say that you sent the medical in May, medical exam. Now, I'm guessing the USCIS sends you 693, medical exam RFE, and then you responded. We have a reports the USCIS not handling this type of situation. So this is why I tell my clients, and then through the TikTok, include your medical initially with everything. That's the best way. Right? Because if you submit the medical through the request evidence nowadays, we didn't have issues last year, but recently there's some reports that USCIS not handling this situation. And then we also heard the USCIS deny the case, accusing that they didn't receive RFE, the medical exam report, through the RFE. So just include it with everything. Now, I'm just reviewing the question here. Yeah, EB3, we do employment base as well. And then, if you want to meet me in person, I do most consultation virtually, call or Zoom. Sometimes it's a paid and sometimes it's a free consultation. But in the case of in-person consultation, it'll be paid. So call us and then we'll schedule consultation for you. Yeah, SB, that was my speculation that the type of disability related to your spouse not able to tell information completely correctly or not able to remember. If you have a supporting documents, medical document, it can be doctor's note or prescriptions and all this. You should bring to the interview. Okay, so just give me 1 second here. Yeah, so going back to user, right? You send the medical RFE in May, and then you haven't heard anything. Well, I just explained previously that sometimes this is not ideal way for you to submit your medical exam and then call the USCIS. I know that it's very difficult to talk to them, but just good idea to call them just in case. Okay, just I'm looking at this. Yes, one of you have a K1 case. Your fiance is in Guatemala, and how long does it take? Guatemala, there is no significant delay like Mexico. Mexico takes quite a bit longer than other posts, but if you do it correctly, 129F and everything from the beginning to the end, it'll take about 6 months to wrap it up. It means that your fiance's case will be approved in 6 months. So typical cases, our cases, and then I posted one of the newer, TikTok video and YouTube that our 129F, the recent one, couple of them, one for India and Philippines, they're approved in 30 days. Very fast, very fast, very fast. So it's a good time to do K1 fiance visa. And typically K1 takes about 6 months from the beginning to the end. And then I'll say that's good timing, for you. Okay. Now, one of you asked whether you can file 129F petition K1, right? The petition to start the K1 online or mailing. As of today, 129F, you cannot file online. You need to print everything and mail to USCIS. And then I'll tell you this, there is different opinions, right? But I believe that, mailing printed package to USCIS is better. That's what I believe. Because, that's, maybe I'm a little bit old fashioned, but I don't like online filing. User, 2412, I explained, you missed my comments that, you need to call USCIS. You submitted your medical exam, in May, and you haven't heard anything. Just call them up. USCIS, and then tell them. Okay. You probably know that you're not able to talk to the agency that sends you the RFE. You are able to call a customer service number only, but you need to call them up. Okay. Okay, so Ado, right? I'm probably missing some of the question here. Is it safe to travel internationally with the 751 extension notice? Answer is, for now, it is safe. But when the Trump was the president, right? When Trump was the president, conditional residents went overseas, whether they returned together with a U.S. citizen spouse or not, were given a hard time. And then it may happen. So if Trump's come back, all conditional residents who like to go overseas, watch out. You'll be given at the hard time at the airport. If you're not together with your U.S. citizen, they will call your U.S. citizen spouse. And then just imagine this situation. They call your U.S. citizen spouse and that person doesn't answer. It can be traumatic. If Trumps come back, watch out, conditional residents. When you go overseas and they try to return, potentially you'll be given hard time. But not now. Okay. Okay, so YG, right? YG asks, is there anything I can do? My case, it's been stuck about 1 year. Only got work permit and social security. I'll tell you this. I tell all the time. If your case with the USCIS is pending more than 1 year, whether you had an interview or not, you are eligible to file mandamus lawsuit against the USCIS to compel them to take an action. So what do you mean by this? When you sue them, the USCIS either approve your case, schedule interview, if they already scheduled interview, second interview, or request for evidence. Instead of waiting forever, you should sue them. And then you need to work with an attorney. Just call us and then we'll tell you how much it's gonna cost, whether we can help you. Now, maybe you try congressional assistant, they're not helping you in most cases. Perhaps you try USCIS service requests. They don't assign those type of inquiry to any USCIS agent anytime soon. So, you should try all of this, but only working solution is to file mandamus lawsuit, okay? Yeah, it said we're talking about the same inquiry. You got RFE submitted last year, November. I don't know whether it's a medical or relationship or A64. Just from the time that you submitted I-130 and 45 is still pending, more than 1 year, contact us. You need to sue the USCIS. Excellence will ask the question how long I-130 takes right now. It depends. When you submit I-130, it means that you have a various case type. So for example, if you have a CR1 spouse visa, either your foreign spouse, it can be you overseas, then it's a faster a little bit. I would say 8 to 1 year, right? That I-130. But if you file I-130 for 601A waiver, the first part, then it will be more than 1 year. If you file I-130 because you have a pending removal, proceeding, then it may take between 1 and 2 years. That's it's just sad. It's slow. Especially when you have a pending removal proceeding and then you got married to U.S. citizen and then file I-130. That takes long. Okay. Sina Williams asks, you just had an interview a week ago. Were you interviewed separately? Where are you located or jointly? And then you didn't get any response. So after interview, it's just like all of the places. Sometimes you get approval same day, next day, within a week, within 30 days. But if nothing happens within 30 days, then usually you need to wait up to 120 days. And then after waiting more than 120 days, you can call the USCIS and ask for the updates. But once again, it has been more than 1 year from your I-130 45 application filing, and now it's more than 1 year. You should file mandamus lawsuit to compel USCIS to take an action. And then I tell many times that if you have a pending asylum case with the USCIS and you got married to U.S. citizen, in many cases, your case, may be pending after interview. In most cases, but not all the time. We have a case that we have a pending asylum case and USCIS never scheduled interview, so you never know. Okay, so then Sina, you're from New York, and then you're interviewed together. So it's a good sign, right? Usually when you're interviewed together, it means that, they have a, better assessment of your relationship than being interviewed separately. Okay. Okay. Well, I mean, David, sorry that I skipped your question, but I have a lot of questions popping up. And then when I sort of select a questions and answer, then, sometime it pass. I'll try to answer you back, but you may ask the question here. Okay. So, Moron. Okay, so then your question is kind of good too. Instead of having 2-year conditional residency, you have a 10-year, permanent residency, and it is based upon marriage base. And then, like, your question is that, will you be given hard time when you go overseas and come back? Answer is probably not. So, those of you who have a 2-year residency, if Trump's come back, you'll be given hard time at the airport, which happened during his first presidency. So that's why I'm just speculating this possibility again. But if you have a 10-year, then probably not, even though it's based upon marriage. Okay. Gotra said that your asylum was denied. Was it by the USCIS or immigration court? Looks like by USCIS. Contact us to see whether we can help you with, appeal, right? Appeal. So when your asylum case is denied, then usually it'll be referred to immigration court, and then you'll have a second chance. So either help you with appeal or help you with a removal proceeding. We do vigorous removal defense work. Although I don't speak Spanish fluently, I have team members who speak Spanish, and then we help you, for help Spanish-speaking clients. Okay, so Yasmin. Okay, so you're getting ready to apply for marriage green card case. Now, your husband looks like a foreign national, right? Went through immigration in Vancouver, and that's the point of entry, not the San Francisco. I mean, he landed in San Francisco to meet you, but the point of entry would be Vancouver. Okay. David, okay, so sorry. Yeah, I just missed your first one, but I see you now. So I'm going to talk about you. Listen, okay? Listen when I talk to you. David. Now, by the way, if you use a little bit easier username, then I will be able to identify and say, hey, like now, David. But if you use like user numbers and all this, it's kind of sometimes difficult, but I'll try to identify which question I'm answering, okay? So it's about the David. Can I file I-130 petition for spouse? And then you have a, okay, it's confusing. As I hold asylum-based green card. Okay, so you're permanent resident, and then David, so you apply for asylum and it was approved. Looks like you're a permanent resident. You like to file a petition for your spouse as a permanent resident. It's an F2A case. I-130, yes, of course. If you need our assistance, call us, and then we'll help you. We'll help you. Okay. So so once again for David, right? Yes, you're permanent resident, right? You survive asylum process. Congratulations, and you're permanent resident. You like to file petition for your spouse. I'm just guessing that your spouse overseas. So yes, we can help you. But the F2A, green card case takes quite some time. And then I don't know when you became permanent resident, but you need to wait 5 years to be a U.S. citizen. So it's going to take some time. So, but we would be happy to help you as well. Okay, now I'm going to see whether there's any the questions that I miss. Okay, I'll just wait. So since I'm waiting for the questions, if I miss, just like the David, post the question again, and then I'll answer. Now. So, circling back to keeping families together parole in place update, right? The district court will have a major hearing on November 5th. It has a dual agenda. One is to rule on preliminary injunction, which is like sort of permanent injunction until the court makes a ruling, But that's not the main point. The main point is to same day, November 5th, in Texas District Court, they're gonna kickstart final hearing on the merits. It means that they're moving into like final hearing to decide whether parole in place, keeping families together parole in place was constitutional or unconstitutional. So they're gonna make a decision. And according to district court's order, temporary injunction or admin stay will be in place until November 8th. So remember, the trial starts November 5th and the temporary injunction ends November 8th. So probably it will be wrapped up by before or on November 8th. It means that we're gonna know whether you'll be able to, whether USCIS will be able to approve pending cases. So that's what's happening November 5th. I'll keep you posted. Okay. So then, GOTRA, 8078 gave us, detailed information. I asked like what kind of asylum. Not fully, but looks like you have an asylum case denied by the USCIS, and then you got married to U.S. citizen. Good for you. Now, so this is what may happen to you, right? And they call us. This is type of case that you need to work with attorney. You're denied. It's not really denied. They didn't approve your affirmative asylum. So your case will be referred to immigration court. So you're going to have a case with the immigration court. But at the same time, you can start your I-130 petition with the USCIS. And then, you have two options. The better one is that when your I-130 is approved, then you can ask the court to dismiss your pending removal proceeding. Or you can try to ask the court to dismiss it right after filing I-130, but chance is not high. So this is something that you need to contact us, and then we'll talk to you. Okay. So just talking about GOTRA 878, right? Your affirmative asylum was referred to immigration court. You have a pending case, removal proceeding with the immigration court, and you got married to a citizen. So yes, you have an option, better option, but you need to deal with the court and USCIS. It's complicated, okay? Previously, okay. Yes, so, one of you asked about the VAWA adjustment of the status, right? VAWA adjustment of the status, if you do it correctly, then, even entry without inspection will be forgiven, and unlawful stay will be forgiven. It forgives a lot of them because it's a humanitarian visa. So if you need assistance with attorney for VAWA cases, we handle family, humanitarian, right, and business immigration and removal defense. Contact us for assistance. Okay. So user 1088 asked the same question, right? What should I do after waiting more than 1 year? After interview. So this is what I meant. Sometime you end up waiting more than 1 year after interview. So, unfortunately, if you sort of log it into USCIS processing time and they say type of New York City, and they say, well, processing time is about 20 months, and then he's talking about case like yours, unfortunately. Your case is pending more than 1 year after interview. You file I-130 and 45 concurrently. If you believe that you have a good case, contact us, and then you need a mandamus lawsuit. I talk about this many times. If your USCIS not approving your case more than 1 year before after interview, like from the time of I-130 and 45 filing, you're waiting more than 1 year, you need to file mandamus lawsuit. You need to compel USCIS to make a decision. Approval, second interview in your case, or the request for evidence, but more likely approval. Okay. Just give me 1 second here. Okay. one of you, Sina, asked the question again. She's thinking about going overseas while her case is pending. When you have a advanced parole, you may go overseas, but we tell all the time that it's not admission when you come back. Your parole. So just be careful. Just be careful, because if your case is denied, just in case, while you're overseas, then you're not coming back. Remember, right? If your case is denied while you're overseas, you're not coming back. It's better to be in the US. So if I were you, go overseas after you have a green card. Okay, Moron asked, the reentry permits is kind of interesting, benefits. So you're permanent resident, whether you're conditional or permanent, right? Maximum time that you can be overseas per trip is a 6 month, right? Per trip. But like, for example, your parents in your home country dealing with a serious illness, you need to go there. It requires more than 6 months. Or maybe you have a job, or you like to pursue some education overseas, then you need to apply for a reentry permit. The reentry permit looks like a passport, yes, and then it allows you to stay overseas for up to 2 years initially, and then you're not losing your permanent residency. Now, if Trump's come back, this will be very important, reentry permits. And then if you need assistance, call us. So 131 reentry permit. Okay. So Michelino, you're Canadian. You're visiting United States, and then you're posting contents online, and then you're getting tips. Now, the U.S. immigration, law, when it comes to unlawful employment, is very, very, strict. So I usually tell this. I'm gonna answer your question, but you're from Canada, other country. You're gonna work for your employer remotely while visiting the U.S. because you've been working remotely for your employer. And then is this unlawful employment? Answer is absolutely it is unlawful employment, even though you're not paid in the U.S. Even though you're not paid in the U.S. Now, in your case, right, Miss Celino, you're paid in the U.S. So unlawful employment. Just be careful. Just be careful. Okay. Eucolomet, you asked a question here. Looks like you did well in 2023, not in 2022 and 2021. This is a tricky question. I will just tell you a general information. Most important one is the most recent tax return. If you made sufficient income in 2023, yes, you can be a sponsor, but just you need to be careful. Okay. One of you asked question about you have a withholding of removal, but you have a TPS, and then TPS travel permit, and then whether you can go overseas or not. You need to call us. This is not something that I can tell you, especially this type of tricky situation. We need more information. So call us, and then we'll see what we can do for you. But just you need to be very careful. Okay, you got paid in Canada, but you're engaging, gainful, activity. You're earning, you're generating inside the United States. So you're not supposed to do that. Okay, let me see whether I am, missing any question here. I think that I covered many of them. You said give me your contact. I'm talking, so I'm not gonna type, but just log it into our TikTok profile. Type, Dr. J. Francis Immigration, right? And then you can find our booking link, phone number, and all that. You can easily find us, or you can message us, and then I can give you a phone number that way. Okay. And then Ultra Max say hi, sir, and then good to talk to you, and thank you so much for joining. Okay, about 8 more minutes left. So I'm gonna talk about processing time. I just briefly talk about keeping families together, parole in place. Major hearing coming up November 5th in Texas. Also, in terms of the live schedule, I do multi-platform Thursday 5 p.m. Central Time, and usually do TikTok Tuesday 5 p.m. Central Time. But next week I will be doing TikTok Live on Monday instead of Tuesday. So next week, Monday and Thursday is the schedule. Now, in terms of processing time update, right? Family base. Now, K1 is still less than 6 months. It's a very good option, less than 6 months. And then I just told you many times that couple of recent 129F petition were approved less than 30 days, about 30 days. Marriage green card case used to be really faster between April and July, right? 17 days, 41 days, 47 days, less than 2 months, and less than 3 months. Now it looks like it's a 6 months. It's taking a little bit longer. Okay, so Ultramax, how much costs divorce process in the U.S.? I don't do divorce law, so I'm not able to answer the question today. Okay, so 5 more minutes. Now, just let us know what kind of topic you want me to discuss. What I can do is that, you probably know that why I call myself Dr. J. Francis, because my name, obviously J. Francis, and I have a PhD, and then, I'm a lawyer, I have a JD, and I was a professor for 22 years. And then I can sort of cover the topic each time and then do Q&A on that topic or any other matters. Recently I've been just answering your questions, but I don't mind giving you some, short, brief overview of each immigration case type, and then I can do Q&A. Okay, SB said that my attorney said we're being called for interview because our marriage is 4 years. And then because instead of getting conditional residency, you're going to get 10 year. That's why you're scheduled for interview. I don't agree. But, there's a reason why your attorney told you that way. I wouldn't, second guess what your attorney is telling you, but that's not the case. We have a lot of cases, 10-year green card cases, not scheduled for interview. It's really case by case. It's about the relationship. But there's a little bit of kind of interesting situation. I had a case a couple of years ago. They were married for 10 years and they didn't apply for green card. You think that, well, we've been married 10 years. Then like our case is rock solid because we survived the marriage for 10 years. Not really. So marriage green card case, it's kind of interesting. If you just started dating, like, sometime you dated 30 days and then, hey, let's get married. Let's go to Las Vegas to get married and apply for green card. That's kind of too fast. Or waited 10 years, like you thinking, well, we love each other. I don't need to be a permanent resident. I don't mind. Wasn't necessary. Now I like to apply. Then USCIS, will be suspicious as well. Why? Applying for green card after 30 days, right? Or applying for green card for after 10 years of marriage. The common elements, USCIS may suspect that you got married for immigration benefits only. Whether it's a fair or not, it's up to them. I don't agree. If you're married for 10 years, you show longevity, commitment, and your case shouldn't be scheduled for interview, but they do. So if you're married quite some time, just don't delay. Just apply for green card and get it out of the way. Okay. Now, okay, so it's a little bit less than 40 minutes. I'm gonna wrap it up. Have a good rest of the day. Now, as I told you many times, I will see you